Welcome to Aspen Leading Edge. I am Patty Roberts from St. Mary's University School of Law, and today's guests are Reid Weisbord. He is the Distinguished Professor of Law and the Judge Norma L. Shapiro Scholar at Rutgers Law School, and David Horton, who is a professor at UC Davis School of Law. Welcome, gentlemen.
Thank you.
Thanks.
Well, I appreciate your both being here with me today to talk about one of the fields that you write and teach in, Wills, Trusts, and Estates. I know that you have a third edition of your book, Wills, Trusts, and Estates, The Essentials, through Aspen Publishing that just was published January of 2024, and that's one of their connected ebooks. So perhaps you can start by telling us what prompted you all to get together and write the casebook initially, why you felt that there was a need for a different book on the market.
I guess what I would say is that we thought that there would be a need for a book that tended to minimize the traditional burdens that are imposed on both students and professors in teaching any course, but in particular trusts and estates. And those burdens come with cases that tend to be only sparsely edited. They tend to run a little bit too long sometimes. Textbooks that come with lots of annotations and note that may be useful for a practitioner or a judge who's writing an opinion on a particular case, but maybe not for a student who's trying to pick up the subject for the very first time. And so the goal, as the title suggests, the title being Wills, Trusts, and Estates, The Essentials, was to pick the most important crucial topics. So curating the topics in a way that focuses on only those that are the most important for a beginner. And the way in which we treat each of those topics is to be selective and concise, using cases not to describe black letter law. What we do is we explain the black letter law as concisely and as close to plain English as we possibly can before we try to apply anything in the context of a short case. And the end result is a rather compact textbook that covers a very broad range of important topics.
So an introductory book for law students. And David, did you want to add to that?
Well, I was just going to say that I came into this project sort of midstream when Reid and our co-author, Stephen Urice, had been working on it for a while. And I was really excited by this opportunity because I thought that Reid and Stephen had this great vision, which was Trust and Estates is a really hard class. And the students are overwhelmed. And one of the reasons they're overwhelmed is that most of them have had no experience dealing with estate planning or estate administration. You've got this old, archaic field filled with jargon. And then the students come to class, already kind of half panicked. And if you throw sort of a conventional hide the ball law school casebook at them, they just sink to the bottom very quickly. And so, I think Reid and Stephen had this fantastic idea, which is let's create a teachable textbook, one that gets right to the point, that tells the students what the law is, and then uses the cases to illustrate those principles. And, I just have found that it's transformed the way that I teach. And I find that the students are just much happier and much more willing to engage when we make things as straightforward as possible.
So one example, I think, of what David is describing is the format for how we analyze the cases that illustrate each doctrine. So as I said before, we sort of cleared away all of those endnotes that follow the cases in a traditional textbook, and we replaced them with a Q&A format. So we pose maybe 3 to 5 questions that try to analyze certain aspects of the case, and we also answer our own questions. So a student who's read the case maybe has their own questions about it. Maybe they are some of the same questions that we're asking. They can walk away from the reading assignment with an answer to that question. And obviously, there's much more to discuss with the case once we get to the classroom, but it's a little bit more interactive and self-contained than the normal way in which cases tend to be presented.
And do you find that the retention is better among your students because of this more simple approach that you take to introducing them to the doctrine?
I
I definitely feel like it is. I feel like I've noticed that the quality of the exams I get at the end of the semester is higher. And I also get a student comment every year that says, thank you for answering the questions that you asked in the casebook. Because, I mean, my law school experience, I remember this so vividly. I would read a case, I would think I understood it, and then I'd get to like the end notes and there'd be some question and I'd feel like, oh my gosh, I don't get this at all. And there'd be no answer. And then, half the time at least, the professor would not answer the question in class. So you just come away feeling mystified.
The other thing that we do in each case, which is somewhat unique to the field of trusts and estates, in almost every case, we have a decedent and survivors that are either related or have some sort of relationship to the decedent. And the challenge with fact pattern, which happens time and time again, is just sorting out who is related to who and why are they fighting with each other.
Right.
And that's one of the frustrations that you might have when you pick up any trust and estates case, but we try to make that a little bit more approachable and easier by including a family tree diagram for almost every case that makes sense to include one, so that you can look at the beginning of the case and within just a second, even just by looking at the diagram, pretty much figure out what the alliances are and who is related to who.
I love that. The family tree diagrams, I'm sure, are a big hit because that is a very, very confusing part of trusts and estates. The other thing I wanted to ask was, what sort of resources do you have for the professors who choose to use this a little more compact and straightforward book?
That's a great question. So I guess a professor who hasn't looked at the book but is hearing that it's so compact might wonder, well, what is there for me to do in the class? And the answer is there's lots. So there's problem sets that appear throughout the book. And those problem sets are mostly based on real cases, sometimes based on more than one case that are sort of synthesized together to illustrate a particular point. And the teacher's manual obviously provides suggested solutions and some follow-up questions that go along with each of the problem sets. But we also have approximately 1,000 slides that go with the materials. And that may sound overwhelming, but you can, as the professor, choose to use as many or as few of them as you want. But what we've done is put together very, very detailed slides for all of the statutes. It's a mainly statutory area of the law. So we have slides for all of the statutes, very detailed slides for analyzing the main text cases in the book, going through the facts of the case, the legal analysis, the holding, and some follow-up questions that don't necessarily appear in the textbook, but that professors can use for classroom discussion. And we also include a number of additional case summary slides to help illustrate different points with additional cases that are not in the book that professors can choose to use or not.
That's a tremendous number of slides, and with a variety of purposes that you're using the slides for, that professors can use the slides for. I imagine there are some professors who would hear, David, your description of, well, the students are happy because we give them the answer. I know there are some professors out there who were like the ones who maybe taught us, David, some of them who taught us who were like, well, you don't want to give them the answer. You want them to get to the answer. And so is it through these problem sets and these questions at the end of the chapter that you're able to get the students to do that analysis on their own?
Absolutely right. So that's the goal. The goal is, I think by the time students are taking this class, we would have hoped that they will have learned how to read a case and how to sort of use those critical skills that come from the kind of classic Socratic hide-the-ball classroom. And now what they're really interested in is knowing what the law is, but then also applying the law, because that's really how you understand what the law is. And so you said it perfectly. We try to tell them what to take away, but then challenge them by having them apply the principles that we've told them about. And I really think it's like, there's a great analogy that someone once used that I'd love to borrow, which is that like legal rule is like a tool. So, you can sort of like look at it and that's one thing, but to really master it, you kind of got to pick it up and use it. So I think that's the philosophy behind the problem sets.
So the people who may have been familiar with your book before now will learn that you have a third edition that's just come out. And how is it different? What have you changed about the third edition that the Academy can look forward to seeing?
So One of the features of this book that we're very proud of is the currency of the material. And one of the research activities that I do outside of editing this textbook is I'm the co-author of an estate planning treatise with Jeff Pinnell. It's called the Kasner Estate Planning Treatise. Jeff recently retired from a very long career at Emory. And what we do to update the treatise is we download every single estate planning or trust and estates case from Westlaw that's issued by any court in any state across the country. So it's a 50-state survey, usually tends to be about 100 to 200 cases a week, and we review them. Now, a lot of them are not particularly helpful. They don't represent any sort of legal development, so we tend to throw out a lot of the cases, but we do harvest a certain percentage of them every week. And so the harvesting for the treatise, obviously that goes into the treatise, but whenever I notice something that might be interesting for the textbook, that gets filed away into an update for the textbook. So what you will find in the third edition is lots of new case citations and updates based on literally the most up-to-date research available to us. And for the slides also include, as I said, lots of small case additions that don't even appear in the textbook. And I'm constantly adding to that repository every week. So we'll continue to update the slides as the edition goes through its 4-year cycle.
That's incredibly recent material then, if you're not only putting that in the new edition, but then adding it to the slides available to the professors over these next few years that this edition is out. David, did you want to share something more about that?
Thanks. I just wanted to add two things, which is one, I just wanted to say that Reid is absolutely phenomenal in terms of his ability to stay abreast of like cutting edge cases and whatever has just come out. I will get emails from him about some issue that I'm trying to like figure out or work on with some case that's exactly on point that was like decided yesterday. I mean, he really has his finger on the pulse of what's going on, and the book benefits from that. The other thing I wanted to add about the third edition is that this may sound counterintuitive, but one of the things we're proud about it is that it's actually slightly shorter than the second edition. And I think what that is evidence of is the fact that as we've been teaching from the book for some time now, I think we've gotten a better sense of, parts of the book that maybe didn't work as well or needed more refinement. And so, our goal is to make the book the easiest book students have to carry around in their bags. So it's a very slender volume, and we try hard to just keep that streamlining going.
So you're also helping their back health, right?
That's the goal, right?
An added benefit for adopting the third edition of Wills, Trusts, and Estates, The Essentials. In this real-time analysis that you're doing, Reid, of the most current cases, are you seeing some themes in what sorts of things are being litigated and decided in the area of wills, trusts, and estates in the current decade?
Yeah, so question dovetails nicely with some of the empirical research that David and I have done outside the textbook that we've also included in the textbook, but I'll let him share some of that. But in terms of some of the themes that I see in the litigation, just a rising number of will contests, trust disputes, fiduciary litigation. There's lots to fight about when someone dies and other people are disappointed by what they might receive, or they're not particularly happy with how an estate might be administered or who gets to be appointed as an administrator or a trustee. And when the stakes are high enough, there's lots of resources to pour into the litigation. And so that is certainly a trend that I think is growing.
David, what sorts of trends have you noticed in the research that you all chose to include in the casebook?
Right. So I think Reid is completely correct that it does seem that as the baby boom generation is dying and the greatest wealth transfer between generations in history is ongoing, that there is what's probably a spike in trusts and estates litigation, definitely all types of claims. And Reid was mentioning the fact that we've written some empirical analyses of various trust and estates issues that we've included in the book. And one of the things that we're working on now that I think we will hopefully include findings from in the fourth edition, whenever that comes out, is we're looking at trust litigation based on trial court records from San Francisco County, California. So there have been a bunch of empirical studies about probate litigation, essentially battles over wills, but there's been nothing so far about trust litigation. And so we've taken a preliminary pass at looking at some of these cases, and we found all kinds of things that I'm very curious to explore more. One of them, for some reason, I find absolutely fascinating, which is that when you go to an estate planner, if you have medium means or you're wealthy, you'll be counseled to create a living trust and to transfer everything you own, if you can, into your trust while you're alive. And it seems that based on the trust records we've looked at, a large number of people do not do this. And so they end up dying with a trust that contains only part of their estate plan, which creates headaches for their survivors. So this is an issue that I feel like has kind of flown underneath the radar, but it calls into question, how estate planners counsel their clients, how useful trusts actually are. This is the type of thing that I just love learning about. And the only way to learn about it is to actually dig into what's happening in court.
Well, you have served as yet another reminder to me that I need to update our documents, because we're exactly in that situation. When you first create it, you create a trust, and then life moves on and you gain other assets and you don't do what you're supposed to do, or at least that's my experience. That's a really interesting perspective to look at. I'm curious, the trusted estate attorneys that I have known in practice typically do not enjoy or have an interest in the litigation piece. I can't tell you how many are true transactional attorneys. They want to do that work with the clients and create their plans, but they don't want to litigate them. So with this increased litigation that we're seeing, especially now with the baby boomer transfer of wealth, are you seeing more lawyers go into this specialty, or are litigators choosing to learn more about this practice area so that they can litigate in this area?
That's a really good question. Hard to say. When I talk to trust and estate attorneys, they are concerned about a shortage of trust and estates lawyers in the future because not as many law graduates are going into the specialty. And the specialty often involves fairly elaborate knowledge and expertise on tax law. And many schools don't even teach the relevant tax courses anymore in gift and estate taxation because the federal transfer tax exemption amounts are so high. And so we have a situation where law schools aren't necessarily teaching gift and estate tax, which is essential for at least high net worth estate planning. They may not be teaching a course in estate planning at all. So maybe they're just teaching the course for which we offered the textbook. And attorneys who are nearing their retirement in the field are worried, who are they going to pass their cases down to? Who are they going to pass their clients, their transactional clients down to? So I don't know if that's a pitch for any law students out there who might be listening. But my understanding is that there is going to be a need. And last time I checked, I don't think we've gotten rid of either death or property or taxes for that matter. So I think those will probably be around for a while.
And there will always be a need for lawyers in those areas. But you raise a good point, because I'm not sure that there are that many law students who get introduced to the subject any more than as the most introductory manner with a course like the one that your book is used with. Do you find that the book sparks an interest? Do you have students each year who come and talk to you about wanting to get into the field?
That's a great question. So it's funny, I practiced for a couple years, and one of the things I love about teaching the class is that it's a class where I can say to the students truthfully, hey, this is an amazing practice area. And so really, I know you probably haven't thought for a moment about going into trust and estates practice, but it's a wonderful lifestyle and you can get hands-on responsibility right away. And you're doing a service for ordinary people. You're not representing some faceless corporation. And so on the first day of class, I always ask, raise your hand if you're interested in going into trust and estates practice. And I'll usually get 2 or 3 hands in a classroom of 135. And then during the course of the semester, inevitably, I will have at least 3 to 10 students tell me that now they're interested. And I just love that. And I've had graduates before who actually have gotten jobs and now are, well-known practitioners in trusts and estates. So yes, I don't know if it's the book or it's just the fact that it's a wonderful practice area, but I definitely think students, at least some students, do get enthused.
Well, I imagine the way that you describe the book as one that gives them answers and allows them to apply the law with the scenarios that you present in the book. I imagine that gives them a great deal of confidence, probably more so than those courses that leave them kind of wondering, what if, or I'm not really sure what the answer is. Have you all thought about, or are the people who are teaching in this area concerned at all about artificial intelligence's impact on the practice of wills, trusts, and estates?
I think there's some apprehension about it. I mean, one thing I learned that I didn't know, because I guess I'm a Luddite when it comes to artificial intelligence. If you were to try to use AI to create an estate plan, and the way you chose to do it was simply, let me type in, I just interviewed my client. I'm just going to type in all my notes from my client interview into ChatGPT and ask it to create a will or a trust. You've just made a huge mistake, because you've just added all of the confidential information that you've obtained from your client consultation to a public artificial intelligence database. And so if there's someone in your client's family who would like to know before the client dies what the client was intending to do, they may be able to obtain all of that information from your notes by searching for it on ChatGPT. That's just one concrete illustration. So I don't even know what I don't know. I just know that that's not good.
No, that's not. David?
Yeah, it's so interesting about AI, and I haven't really thought about it, but your question made me realize that there is this tradition in especially will making of doing it yourself. There are many states allow you to create a holographic will where you handwrite it. As long as it's in your handwriting and signed by you, it's legally effective. And then, other people just simply try to make their own wills. They say what they want to have happen to their property after they die, and then they get witnesses and they skip a lawyer. So, it's entirely possible that we're going to see a flurry of generative AI generated do-it-yourself wills. And it'll be absolutely fascinating to see, how good are they? What are their contents like? Do they contain whatever the equivalent is of a hallucination? It should be really interesting.
It will be interesting. And perhaps in some ways terrifying, as the description that Reid gave us for his scenario. Well, I thank you so much for sharing with us what we can expect to find in the third edition of Wills, Trusts, and Estates, The Essentials, through Aspen Publishing. And now I'd like each of you to answer the question that I conclude all podcast episodes with, and that is, what are your predictions for the future of legal education in the coming decade? And Reid, would you like to start?
Sure. Where I see legal education heading, and I'll sort of stick with the theme of legal textbooks, is trying to meet students where they are and find ways to allow them to learn in ways that may not have been our particular learning style when we were in law school. So I'll just give you a concrete example in my own class. I tell the students, if you prefer to read the slide as opposed to the textbook, if that's more helpful to you, do what works for you. And I think that that's a trend that's going to be continuing over the next decade.
David, what are your thoughts?
Yeah, I think that's very well said. And the only things that I would have to add is, or I think I should add, are one, I think you might see some loosening of norms with remote instruction as schools try to capitalize on the fact that we can now Zoom and, reach prospective students all over the world, asynchronous learning, other ways that, we might actually take the teaching we were sort of forced to do during the pandemic and find a way to use it more to our advantage. And then the other thing is, with tuition being so high at so many institutions, it does seem like there's more of a push for professors to try to cater to students and greater awareness of the fact that different students have different learning styles. So I definitely can imagine a universe in which sort of the old school Socratic classroom where you attend class and get grilled and everyone is sort of unhappy yields to a more kind of student-centered form of instruction.
Certainly the schools that have the description you had in the latter part of your comments might have a competitive advantage with the generation currently coming to law school at traditional ages. Well, I thank you both, Professor Reid Weisbord from Rutgers Law School and David Horton from UC Davis School of Law, for sharing with us information about the third edition of Wills, Trusts, and Estates, The Essentials, through Aspen. And if you enjoyed listening to today's episode, you can find additional episodes on the Aspen Leading Edge podcast webpage or on your favorite channels with other podcasts. Thank you.